All right. So we'll start with our presentation quickly, and then we will move on to the actual webinar. So I'm sharing my screen right away with you guys so that we can have a quick introduction of HR Success Talk. Can somebody confirm if you can see HR Success Talk presentation?
Yes.
Okay.
Yes, we want to see.
Thank you. So let me just quickly give you a brief on what HR Success Talk is all about. So HR Success Talk is a HR community with 30,000 people across India who are basically our members and are connected with us. The objective of HR Success Talk is to basically provide knowledge, share knowledge, learn from each other, and build a network of HR professionals and business leaders across India. If you are a member of HR Success Talk, these are the three things which you normally get as a result of it. You will get an opportunity to share your knowledge with others. At the same time, you will be able to learn from others and grow your career. You can find an opportunity to get mentors. There are very seasoned HR professionals who are part of this network. So you can reach out to them, you can approach them and connect with them and make them your mentors. At the same time, there are a lot of seasoned HR professionals who are part of this network and willing to find mentees to guide them in their career. So it is both ways. The third thing is networking. You get an opportunity to meet business leaders here, HR professionals here. So you can use it for any purpose you wish to. There are various ways people use this networking. Some use it to get more knowledge. Others use it for getting jobs. Some use it for business purpose. So it is up to you how you want to use the network of HR Success Talk. This is our learning ecosystem. Meaning there are so many things which we are doing right now to make sure that we reach to every individual who are part of this network. The first one is webinar, which is right now. You all are part of webinar right now. You are participating, you are joining, and the purpose is to learn something new. We also have HR forum where people can go and ask their questions in case you need to find some recent notification or want to download some policy and formats. You can go to our HR forum there. You can go to our various social media platforms like Facebook, LinkedIn, and Twitter, and you can find us there. We keep posting information about various new things plus our initiatives on the social media. We also have HR Strings Meet, which is basically in-person panel discussions. Nowadays, it is not possible because of the lockdown. So this is put on hold. We have YouTube, which is basically our learning channel. You can go to our YouTube channel, HR Success Talk, and there you can find a lot of interviews which can be beneficial for you. And if you have an interest on a particular topic in human resource, I'm sure you will find it, and you can learn from there. We also have assessment and certifications. This is basically a vertical which helps us to assess people and give them certifications. So today itself, we have launched a certificate on design thinking in HR. So if you are interested, you can go to our Facebook page. You will find the registration link out there and you can register yourself. Before the design thinking in HR, we did a certification in HR analytics. HR awards, we reward HR professionals on various achievements they have in the field. We did our first HR award where we have recognized young HR professionals. Now we are about to launch our HR awards for women leadership in human resources, L&D, and social causes. We have our website, hrsuccesstalk.com, where you can go and find more information about us. You will find a lot of blogs written by very prominent HR professionals. So hope that will be helpful for you too. These are some of our digital social media and digital presence. We have 23 members on forum, 30,000 members on our Facebook page. So you can go there. If you want to be our volunteer, meaning if you wanted to help us in driving this cause, Right now, we have a team of 41 volunteers. When I say volunteer, these are the people who are basically working to make everything which I just said possible. If you want to be our volunteer, then you have to have a zeal of helping others. This is a voluntary act. There is no payment for any services given to this community. You should be willing to invest your time, and you should have eagerness to that. So if you want to be a volunteer, you can go to our page as well and send us a message. Our team will reach out to you. These are some of the glimpses of our previous events. These are actually our HR Strings Meet when pre-COVID, when we used to do all the events, in person. Nowadays, we are focusing more on webinar. Our team consists of advisors and our committee members and volunteers. These are some of our advisors who help us to drive the vision and make all the things which we are doing right now possible. With that said, I will stop the presentation. In case you have any questions, I will be more than happy to answer. All right. Great. So as we don't have any question, we can move on to our actual event, which is basically finding out different kind of labor and employment laws during this pandemic. And as you know that many of us are HR professionals here, organizations are going through tough time, the businesses are going through tough time. And in this situation, somewhere organization is trying to find out some sort of answers for themselves. And then here comes the labor laws and employment, because it is not very clear to people that how labor laws and employment laws should be treated during this COVID-19. Everything, there's a new things happening, new laws coming, the notifications coming. So somewhere I think organizations are not very clear on various things which they can do during this time. Hence, we thought that we should come up with this webinar where we can call upon Mr. M. RADHA KRISHNA MURTY to help us answer some of the questions which many of our members have. So we have collected some of the questions, and we're going to ask him and take his opinion. But feel free to write your question on the chat box. In meanwhile, I'll try that once all the questions are finished, we will be taking questions from the audience and ask RADHA KRISHNA MURTY to answer those questions. With that said, let me welcome and introduce our prominent speaker, M. RADHA KRISHNA MURTY. So let me give you some of the background about him. So he is basically a corporate legal consultant and advisor, and he's been in this role since 1987. So now you can understand the kind of experience he bring on the table right now. He is also practicing as an advocate in the High Court of Andhra Pradesh and Telangana, in the area of industrial and labor and employment and corporate legal matters. I have, I myself heard RADHA KRISHNA MURTY ji on various webinars, and the kind of clarity he has on the labor law related matters is not only COVID-19, but in general as well, is really incredible. And I think all of us can use this opportunity to clear our doubt if we have any during this time. He is also a member of Andhra Pradesh Minimum Wage Board Rationalization. He's also a lifetime member of Andhra Pradesh High Court Advocates Association and National HRD Network. So I would like to welcome M. RADHA KRISHNA MURTY ji today on this webinar, sir.
Yeah. Good morning to all of you. Thank you, Mr. Govind.
Yeah.
So total today now we have about 46 participants. Shall we go ahead with this? Shall we start?
Yes, sir. And we are also live on various other social media platforms where a lot of people are watching us there.
Yes.
And you will get a lot of questions from those platforms as well. So I would suggest that we should kick off because we are always time bound. And I think there are a lot of conversations which we all need to have. So I would like to start with the very key question, which actually comes in everybody's mind nowadays a lot. It is a dilemma from employee side, but it is also a dilemma from employer side. So the question is basically that in this situation today, can employer lay off employees during this time, maybe after the lockdown? What are your views on that, sir?
Yes, Mr. Govind, and this is the question that is boggling to almost every employer. That is the order of the day today. It is most unfortunate, it is unforeseen and unfortunate. Before we go into the legality, I always believe that the legal, illegal are all secondary aspect. To run an industry, what is that the industry requires, what is that the employee requires, that need to be looked into. Basically, the being human is more important than to be the human being. But at the same time, we have to look always for a win-win situation, not win-lose or lose-win.
Sorry to disturb. Sorry to interrupt. The screen is freezed. We are not able to see. We can just hear.
I can hear and see you pretty well. Yeah. Is there anybody else who is struggling with the sound and the screen? Because it is perfect for me.
Yes, yes.
Is it okay now?
I think you should go ahead. I think there might be some problem from our audience, particular audience, but you can go ahead. Rest everybody can see you and hear you properly.
Is it now? Am I visible and the screen is okay, Mr. Govind?
It is, sir. It is very much visible and you are loud and clear.
Yes, yes, yes. The thing is that as I now discussing about it, being human is more important than to be the human being. It should be win-win situation, and by the same time, it should be mutual and reciprocal. Employee also should appreciate the present situation of the employer. The employer also has to equally understand all of a sudden if the employee is laid off, removed, and what are the other methods to win over the employer, to help the employee to win over the present unforeseen circumstances and other things. Because the basic is that the job of the employee exists only when the industry exists. That is why everybody has to look at the employer also, because the existence of industry is must. That is one aspect. The other aspect is that mostly the understanding between the employer and employee. Yes, present situation is that if an employer has to bear the additional burden owing to this COVID situation, March 22nd, I think, is the date that lockdown has started. So of course, that is the financially ending for most of the companies, unfortunately. And in the last week of the last quarter, they had some setback to reach their targets and business targets and other things. And always this business target of the previous financial year would definitely help them in various financial aspects before the financial institutions or whatever it is, even for the business reasons or whatever it is. And nobody thought that this would be extended too long, and now it is the reality. And it is not the thing that overnight it is going to be over, and ultimately everybody has come to know the true reality is that one has to live with it, and it cannot go until unless a vaccine is found. And the present situation is that during the lockdown period, earlier the Ministry of Home Affairs has issued GOs. Those GOs during the lockdown period, the full wages to be paid is one aspect. The other thing is that removal and all laying off is not permitted. And subsequently on 18/5, somewhere around 19/5, I think the Ministry of Home Affairs has come out with other GO, whereas they have cancelled all other GOs which were issued by the Ministry of Home Affairs from time to time till such a date. That is there. Now the issue is that presently laying off is again differently used by different companies. When it comes to the software and ITES industries, laying off means it is permanently laying off the employee. It is retrenching the employee. It is termination of employee. When it comes to the manufacturing sector, laying off an employee means it is a temporarily layoff, where the employer is not able to give work for a certain period owing to the business reasons, temporary layoff. Now there should be a clarity that which layoff we want. If it is a permanent layoff, it amounts to retrenchment. and the IT, ITES and service sector are covered under the Shops and Commercial Establishment Act, whereas these manufacturing industries are covered under the Factories Act. But Industrial Dispute Act is applicable both for the IT, ITES industries. In certain of the states have given certain exemptions in respect of certain of the provisions of the Shops and Establishment Act for the IT, ITES. Now coming to this Uttar Pradesh, Madhya Pradesh, Gujarat, and so on and so forth, some of the industries did give certain exemptions from the applicability of the industrial laws to certain extent. These are all aspects that are there. And another thing is that where the employee working under the shop and establishment, under the commercial establishment, in the commercial establishment or the manufacturing sector, he can seek remedy either under the commercial shops and establishment act or under the industrial dispute act. That's what the Supreme Court categorically said. Where the concurrent remedy is available, it is for the employee to choose one of the remedies, but he can only choose one remedy. But having chosen one remedy, a other concurrent remedy cannot be avoided. That is one aspect. Now, Mr. Govind's main question when we come to issue that whether they can lay off. Yes, they can lay off. And if it is a temporary layoff, that is a different issue. If it is a permanent layoff, that is a permanent layoff is a retrenchment. You'll have to comply with the provisions of the Industrial Dispute Act in respect of the permanent layoff. What are the procedure that is to be in respect of payment of retrenchment compensation or pay notice or pay in lieu of notice, so on and so forth. And also the last come first go, and whoever the junior most has to be, and the seniority has to be worked out. It is not the seniority of overall employees. If you have 50, 100, 200 or 300 or whatever it is not that seniority. Seniority category wise. You might be having in when it comes to the manufacturing sector, you might be having the fitters, welders. The welder, senior most welder may be junior when in the welder category. You may be senior, overall seniority of all the employees. So in each vertical, they will be having different employees. The seniority has to be looked into and worked out on the basis of each vertical, because that is how it is to be followed. That has to be followed. And another thing is that where the number of employees under Section 25N and 25O, Chapter 5B of the Industrial Dispute Act, where the employees cross, the number of workmen crosses more than 100 in certain states, 300 in certain states, the employer need to take permission. Of course, it is not required where the ordinance has been brought. Some governments now has brought an ordinance, and as per the legal validity of ordinance is concerned, where there is no possibility of making a draft bill and inviting objections over the draft bill and again passing it as an act and sending it for the president assent and all. And to meet the exigencies, the constitution does permit the state governments, because it is mostly the labor laws, most of the labor laws are in the concurrent list. There are normally, one is the union list, the other one is the state list. Any law which is in the union list can be amended only by this union, Government of India, which is in the state list by the state. Where it is in the concurrent list, union also can amend, the Government of India also can amend, and the state governments also can amend. They brought an ordinance. This ordinance shall be in force up to 6 months. And before that, it can be amendment can be brought and it can be enacted and so on and so forth. This is the procedure that is to be followed. Yes, Mr. Govind.
Yeah, and
I think I'm going a bit fast. Or may I request the participants to express their view, and are they able to follow me, or do you expect me to go a bit slow? Because I always believe in accomplishment but not completion.
Yeah, and I think I think maybe a little bit slow will definitely gonna help team. Although I see messages like this saying we are okay, we can understand. Some are saying okay, a little bit slow. But I think yeah, we are getting you like most of the time. But if you want to be a little slow, that's absolutely fine with us. I see Priyanka saying slow is better. Okay, so here is the answer of your question, sir. So, but yeah, I like this concept where you mentioned about it has to be both ways. It has to that we have to look at from employee perspective and employer perspective both, because no employer like to lay off people, right? This might be the business conditions are like that they have to take this decision. So I think both have to understand each other perspective and come to a mutual consensus. And I also understand that what are the technicalities now if an employer is in a situation to lay off. So I think it is pretty well explained. Not only IT, you took us to the other industries as well and try to give some light out there. So I think it's very, very well explained. So thank you very much for that. I see that some of the people were commenting while you were saying about furlough. And one of the question I have is on the furlough itself. But I'm going to ask it a different way, and basically it's furlough as well. So the question is that can we ask an employee to take forceful leave or leave without pay? And this is basically furlough. So what's your opinion? Is it legally allowed? Should we do it? Shouldn't we do it? If you do it, how do we do it? Things like that.
Yes, Mr. Govind. The thing is that the US laws are different from that of the India. Mostly IT, ITES industries. US, they can ask the employee to go on leave for a certain period, and then the leave we can cancel, or the company can recall him or re-invite him depending on the workload or the exigencies. Whereas in India, leave is a privilege given to the employee. Let us understand first. It is a privilege that is conferred as a right under the presence of law. And leave, it is the prerogative of the employee to avail leave or not to avail leave. And the employer cannot force the employee to take the leave or to apply for the leave. Leave is at the choice of the employee. The other thing is that sanction of leave or rejection of leave is under the exclusive domain of the employer. Depending on the exigencies, he can accept or he can reject or he can deny the sanction. But availing leave, like the sanction and non-sanctioning, is under the exclusive domain. Availing leave is under the exclusive domain of the employee. So, as per the provisions of law, the employer got no right to compel any employee to go on a compulsory leave.
Got it. Okay. But as you said earlier, if employers are going through a tough time, and if they find this as one of the solution to cut down to some of their expense, as opposed to taking a layoff decision, they want to avoid a layoff decision, so they are looking at this as one of the solution. Law doesn't allow this. What is your suggestion to such employer to do in this case?
Yeah, definitely there won't be a log without key. Always every problem got a solution. It is only the perception, and we'll have to look into the positive perception into the problem, and then when we look into the positive perception of any problem won't be a problem at all. For every law there is a flaw, there can't be law without flaw. It's all depends. And another thing is that when you enforce law, though being a lawyer, I always say mitigation of litigation is always best. Why? Because litigation is a speculation without knowing the destination. That is the order of the day. And there are two aspects normally we do consider. Any person obliges the other person, be it an employer, employee, or whatever it is in human relations. One is out of fear, the other one is out of respect. If you want to impose law out of fear, they accept it. And if you can convince the person, do the counseling, win over the person, win over the employee, I mean inner winner. An outer winner is the one who imposes law out of fear the other person. Inner winner out of self-conscious, knowing fully well, understanding the other person, understanding he accepts it. When we become inner winner and enforce and implement, we can avoid litigation. Ultimately, what I mean to say is we have to convince the employee the present situation. Another thing is that where there are no savings, where there are no profits, savings are profits. Savings means following austerity measures. Yeah, suppose where you cut down the cost, because nowadays in view of the present COVID situation, the client's position, the project's position would adversely be affected. And another thing is that there might be projects for the ITES in that there may be a renegotiation of the prices, renegotiation of the things. In the renegotiation, the salaries which are being paid by the employer and the overheads that are being met by the employer at present is pre-negotiation, pre-COVID period. Now, when we renegotiate as against increasing price, we are reducing price. So, proportionately, one has to reduce the expenditure as well, cost cutting also. So, under these circumstances, it is better one-to-one the employer and employee. Employer in the sense, top man need not talk always with the lowest employee, different employees, immediate boss, and they got to explain the situation. Another thing is that instead of asking him to go on leave, he can be persuaded where the employee himself applies for leave. You see, something is better than nothing. If the employee completely, say the employer follows the legal procedure, due process of law and terminates, and his bargaining power he would be losing when he goes to the better prospects without any employment. While in employment, he goes at least some, he would be in a better position. I can't say in the present situation, he would be in a better position. Or rather, he can explain the situation. The employee should be convinced instead of facing the termination. Otherwise, if he cannot say, instead of facing this, following the procedure, not termination requires undue influence and other things. And on one hand, a termination letter, the other hand, asking for a resignation. It is not fair. It is not fair also. Because as I said, being human is more important than to be the human. That is what I just named it as a PPFT scheme. I am just cutting it as a say. What is a PPFT scheme means? Place paper for place termination. That is bad in law. That is bad in law. Another thing is that it is not that today we can get rid of the employee, but by the same time, the opinion what we are leaving in his mind would be there forever, and it spreads a bad news about our company. Nowadays, glass door, everything has come. Let us also keep our, while reducing the cost, and we also have to maintain the image of the company because we are not going to close today. It is only a pause. It is only a comma, not a full stop. We have to continue in the business. Therefore, persuade the employee, do the counseling, explain him, let the employee come forward that he is willing to, because there is another option also available. Suppose you have 50 people, 50 employees working with you, you got work only for 25 employees. Instead of retrenching the 25 employees, you can ask these employees to work for 4 hours. It is also as a choice, not compulsion. You will tell the employee, as against working for 8 hours, let us share whatever the work is available and distribute to all the employees. As against working 8 hours, you will be working 4 hours, so that the employment of all 50 can be protected. And so that, and sometimes the underemployment, it's called as an underemployment. Just employment, overemployment, underemployment. And when you are so busy with the projects, it is overemployment. And sometimes it is just employment. On the bench, it is underemployment. Completely keeping on the bench also for a long time. Any employee who is now who is workless for a certain period, he would be workless after some time. So let any employee not be without any work, rather completely keeping on the bench. You just trace the situation. If the employee comes forward to opt for part-time working, you can give it, but it is only with the mutual consent, mutual agreement between the employer and employee. That is one aspect. The other aspect, Mr. Govind, what I can say is that the terms and conditions of employment, where they say that whether when he works for 4 hours, he would be paid proportionately. That is 4 hours wages as against 8 hours wages, so that it is protected. In the meanwhile, you can also say ultimately to give employment long run, you can say certain of the employees where they got to try elsewhere, where they get full-time employment, we are not stopping them. They are at liberty to persuade their full-time employment as and when they can get them, they can go. That is one aspect. The other aspect is that certain of the employees do ask some mic problem. Can you keep the mic of the others mute, Mr. Govind?
Yeah, we just did it, sir.
Some interception is coming in between.
Yeah, we just muted some of the participants. So you go ahead.
And anything they got, they can put it in the chat, and Mr. Govind would put question to me, the queries to me, I would be able to answer. And every question would be answered, nothing to worry. And what I mean to say is that there is realignment of work, and where with the concept of the employee, you can say, and if you have to give time for them, if they agree for it, that they are willing to work for 4 hours a day or 5 hours a day. There is another concept in one of the companies what I suggested that they did implement it is going well, where they are working 50% of the work, they get 60% payment. Where they get 75% of work, they get 80% payment. 100% is 100%. It is options given to the employees and they have given. It is not that morning we put it, communicate in the intraday and expect them to give in the afternoon the reply. That also, justice not only be done, it should seem to have been done. And the opportunity not only be given, it should seem to have been given. That is more important, where he gives a free consent. Give him for a couple of days time to think about it, revert back to it, then they would be, or else take the employees into consent, put forth the projects what you have before them, and by having a virtual conference, and invite suggestions before you implement. You ask them, that is winning over the employee. How do you, what do you suggest? These are the projects, this is the thing, and they know as per the industrial engineering norms, how many persons can do this work and available work. And also explain to them, mostly the communication gap. Why? Because the only the top master knows the business scenario. The lowest employee doesn't know the business scenario. He is only concerned about monthly EMIs and protection of his employment and other things. So he might be knowing in the micro level. So it is better the CEO address first about the company, its business scenario, and its future prospects to all employees from bottom of the employee. Even any person, right from the junior most engineer to the topmost person, they should be they should think about it. The way the CEO makes the presentation, and you would be able to win over rather simply saying, the business is not doing well, I can't afford you, you got to leave. With this, or interesting some junior most trainee or intern HR, I don't know what do you do, I am fixing the target of 20 people to you, you persuade them, somehow and downsize the workforce and you relieve it. It should not be done. And the CEO should address each and every person virtually, explain the business situation, and ask them to cooperate with the company. Then it would be easy. These are all not the legal. It is a strategic legal management. What I call it is that has to be done. Another aspect, realignment of work, proportionate working. And another thing is also suppose you don't have work. You can also propose to the employees, they will be given 3 months time, up to 3 months they will be paid 50%, another 3 months they will be paid 25%. They can look for some other employment with the mutual consent. They need not even come to the office, they need not do any working and other things. With the articles, they can upgrade the skills and try elsewhere. This is also the option. But anything should be mutual. The other thing that comes to is many employers do put the queries to me whether there can be a salary reduction. Suppose earlier you are paying annual package 5 lakhs per annum, 6 lakhs per annum, or 10 lakhs per annum. Whether there can be any salary reduction, that's what they say. No, unilaterally the employer cannot do any salary reduction. However, in the event, in the appointment letter at the beginning threshold, when the employee joins, if you can put a clause in the terms and conditions of appointment, owing to the reasons of economy or owing to the reasons of business, owing to the reasons of any other reasons which are beyond the control of the employer, if the employer cannot afford to the remuneration or compensation benefits as has been offered at present, the employer shall have every right to reduce the agreed compensation benefit or compensation package to 30% or 20%, but not more than that. If you put it in the initial appointment terms and conditions, then you can do it because the employee at the time of joining gave his unequivocal acceptance to all the terms and conditions of his appointment, because then it has done. Otherwise, without there being a clause to that extent, you forget about the labor laws for that. There are certain, basically in the industry, we must understand there are two categories of employees. The first category of employee is the employees who come under the definition of employee under the Shops and Commercial Establishment Act, workmen under the Industrial Dispute Act. The other category of employees are the employees who doesn't fall under the definition of employee and workmen, who fall under the managerial or supervisory cadre. For the managerial and supervisory cadre, certain of the labor and employment laws doesn't apply. And of course, in the new wage code, there is no such this thing that is yet to come into force and has not did not come into force. Everyone, even a general manager, can approach under the Payment of Wages Act. That would be the new wage code that hasn't yet come. That is a different issue. Presently, the question that do come is that he doesn't fall under the workman category, he doesn't fall under the employee, doesn't fall under the employee category, and he is employed in the managerial position. Can I reduce the salary? There is another thing. No, whether he comes under the labor laws, under some or certain of the labor laws or not, whether he is a worker or not, there is, besides being obligation under the labor laws, contractual obligation is there. An appointment letter, an agreement between employer and employee, an offer. What is a contract? Offer and acceptance is a contract. Even if we give it on a white paper with terms and conditions where both the parties sign, it is a contract. So as per the contractual obligation, the employer has committed certain salary and he cannot unilaterally reduce until there is a saving clause that owing to the reasons of economy and convenience for business reasons, if the employer cannot pay, he can reduce, he got a right to reduce. So wherever such clause is not there in the appointment letter, if you want to reduce the wages, you got to speak to the employee one-to-one. You can arrive at a mutual agreement, and after arriving at the mutual agreement, certainly you can reduce the salary, but not unilaterally. Anything bilateral is always better, but not unilateral. Yes, Mr. Guru.
Yeah, so I think you have also answered one of the key questions, which was there in our mind, and I see a lot of people asking those questions around that, which was basically to understand whether an employer can reduce pay and allowance or can also cut the pay. So I think what we hear is that it is not possible, even if it is not doesn't fall under a workman compensation, because there are contractual obligations which we need to. I'll come back again on this question because I see that a lot of our audience are asking questions around it. Maybe it's good to pick it in the end as well and kind of reinforce it one more time, and maybe answer their specific questions, because they're coming up with very specific questions, which is very good. Here is another one which disturbs a lot of people. So when this pandemic started, people were already having some offer letters in hand, and what employers started doing is that they started putting these offer letters on hold or asking people to defer their joining or just cancel it. So the question which comes is whether an organization can recall offer letters issued to, maybe there are fresh graduates from campus or maybe lateral hires. So what is your opinion on that? Can an employer do that?
Very good question, Mr. Govind. And the thing is that before that, what I got to see is that in most of the cases, the appointment letters or the agreements or non-disclosure agreements or whatever it is, IPR agreements, and most of the cases I find out of my 33 years of experience dealing with about 50 and 60 odd companies, good work and concentration is not there on drafting of these letters. Whichever drafted earlier, mostly people are copying it. It is cut-paste technology, what I call it is. And I find even in bigger companies, when I go through the other day, one of the clients did ask me to vet the documents. So I have gone through various documents from selection to the separation, recruitment to retrenchment, where I have seen so many negative covenants which cannot be enforced are also still being carried in the appointment. So by virtue of those negative covenants, because somebody has put it, we are putting it, and somebody else also put it because we are putting it. It is like Woodward's gripe water advertisement. Why baby crying means feed Woodward's gripe water, and that's what my mother gave me, my grandmother gave me, so on and so forth. Shouldn't be like that. So it is the time now one has to re-look into the terms and conditions and the phrases, the covenants of the employment contracts where we have to look into it. Yes. Using generally answering casually, what is there? He hasn't yet joined, and there is no employer and workman relationship, and you only give an offer before he joins. You can cancel it and all. That is the general answer. No, it is not maintainable according to me. Once when you have given an answer, once you have given an offer letter, either for the freshers during the campus selection or whatever it is, or for the lateral hires. First, let us think from the, let me be a devil's liar first, from the perception of the employee. When we look everything from our end, it looks positive. And let us also be a devil's liar. I am an engineering graduate. I am in my 4th year or whatever it is. I got selected somewhere in the month of January, and certain times people even pick up too early also. Very beginning of the academic year, maybe in the month of June itself. And they will say from December you be my intern, and afterwards you can be on the rolls and so on. And suddenly this COVID situation has come. Where all I got the other offers during the heydays. Because I have been selected by you, I have forgotten all those things.
Yeah.
And now when coming to the time I want to join, and I say you have to join, no, you haven't joined, and I recall anything, any person to make to believe, and inducing any person to make to believe, and not fulfilling the promise amounts to cheating. If I am permitted to put it there, because we have to meticulously see. If I am permitted to put it, you are at liberty to refer section 420 of the IPC, because we know the name of 420 and the other thing. We usually use it in the common language and other thing, but let us use it in the academic section. If you look into the definition of 420, making any promise, inducing any person to believe the promise and not fulfilling the promise amounts to cheating. That apart, forget about the labor law. The thing, labor law doesn't none of the labor laws for that matter, be it an Industrial Dispute Act or shop and establishment, they don't talk anything about the offer. Nothing is mentioned about only appointment letter after joining, that is the procedure. This is offering it. They don't talk anything about it. So under the Contract Act, you have promised. Now it comes to breach of contract. And the employer says from 1st June onwards you have to come. And there is also another clause that they say that after joining you should work for minimum 2 years. Even that, another guy, there are certain extents. You should not leave it. Forget about joining, forget about 2 years. If very employment itself is it. So this is possible only when you carefully draft the offer letter. When you give an offer, this offer is only a provisional offer. It doesn't confer any right over you to claim employment. And owing to the force measures or any reasons beyond the control of the employer, if the employer cannot, if the company cannot offer you the employment, the company got every liberty before you join the services to cancel or recall this offer letter. If you put that particular clause, then you are. Because it is not that we getting ourselves convinced he hasn't yet joined. Even if it goes to the legal scrutiny, it should stand. So that is how it is to be drafted. Another thing is that it is out of context, Mr. Govin, but I usually, in several seminars where I address, I usually it. The thing is that what they say, offer letter, they take the offer, even for the lateral hires or the freshers, and finally when they were to join, they don't join. What if for the employer if he doesn't join? Especially the problem arises with the lateral hires, because it is a 3 months notice and 2 months notice that is required to be given for the, and if at all the employer has to pick up another talent, a new talent for that, you got to wait another 3 months. In the last moment, if the already person who has been selected and the talent who has been hired and selected and was to join. So can they say that can I sue them? But you also have to put in the offer letter that you are required to confirm this offer on or before such and such date, and you are reporting. Once if you confirm this, you cannot recall this. In the event you recall it, and he would be making himself liable for payment of liquidated damages. So having given consent, he also gave his consent that breach of contract would make him to land in the payment of liquidated damages, inviting a liability for it. So those clause has to be specifically mentioned. And offer is a provisional, and most of the companies in the software and IT, even the appointment letter, they call it as an offer letter. Offer is a letter, it's a provisional offer before joining. After joining, they give the appointment letter which fulfills the terms and conditions, salaries. There is a difference between, if we can distinguish the difference between offer and appointment, these two are different, but it is clear. Another thing is that mostly the service sector they are having that with, and mostly certain of the IT industries, I may be wrong, and there is a myth that these labor laws are not applicable to them because the employees employed by them are white collar employees. This white collar, blue collar, green collar, all these black collars are all management terms. They are not the legal terms.
Yeah.
Legal term is workman, non-workman, employee, non-employee, manager, and supervisor. So this is how it is to be looked into. And in the especially service sector or the IT sector for that matter, if you look into it, they use different nomenclature: junior software engineer, senior software engineer, analyst, senior analyst, junior analyst, or a business analyst, or a programmer, or a developer, or a junior developer, so on and so forth. Associate, junior associate, consultant, junior consultant, so on. All these employees come under the definition of this labor laws. Only the team lead onwards, who supervises, who enters work, is exempted from the coverage. That
Yeah.
of the labor.
And I think you touched upon a very interesting point that many a times the offer letter, appointment letter, I don't know, increment letters or termination, I don't know what kind, all kind of letters which we do in our organization. Many a times we don't give that much of due diligence and don't get it vetted by a legal person and just try to copy paste from others, or go Google and find some clause and copy paste and make just change of the name, change the name of the company to our company, and just let it go. But we don't understand that when situation like this comes, or any kind of dispute or disagreement, this is the piece of paper which everybody will go through. And if it is not being articulated, considering your organization interest, employees interest, your culture, your values, everything in mind, I think it is gonna be a problem when question like this being asked. So I think very well said, and I hope that everybody on this call will be able to put some due diligence to those kind of letters and review their letters at least once. So I think that's an important lesson for all of us. We have.
There is one more issue. Yeah. In appointment letters, normally we do put it that you shall abide by the terms and conditions and the handbook or whatever it is, my HR manual or handbook, whatever name you put it, they will be binding it. And the handbook is not communicated to the employee. And you will be saying that the terms and conditions that are mentioned in the handbook or HR manual binding, not only the present terms and conditions which may come into force from time to time, the code of conduct and discipline. So without the person knowing, giving consent, that is not a valid contract. He must be he must be. So whenever you want to put such conditions, and along with the offer letter or whatever it is, appointment letter, these conditions are to be enclosed, and he has to give consent and affix his signature in token of acceptance of the same. Only then the employer can impose certain conditions over him. But all these conditions should be in consonance with the provisions of law, and it should not be in deviation. Any contract in deviation of law is void ab initio. That is one aspect. And one classic example I give you how it is being carried on. In many of the companies, they say that if the employee leaves the employment, non-competing clause, he should not join with a similar organization for a period of 3 years, 2 years, or 1 year, so on and so forth. They would put it there. And the Delhi High Court in unequivocal terms categorically held such a clause is bad in law. It is a negative covenant. The employer cannot restrict the employee from accepting the employment in the same company, in the similar business, not who is doing. Because when he got a domain, he becomes a domain expert. When he is working on a particular domain, how can he get some other domain? And does the company expect this company employee to be idle after leaving the company? Whether this company is paying any substance allowance to that employee during that period of a couple of years? According to me, even if the substance allowance is paid, still it is a negative covenant because right to live is right guaranteed under Article 21 of the Constitution, and the technologies today is tomorrow absolute technology. If I am out of employment, I am workless and I will be worthless. So that will not be accepted. So these clauses I do see in several appointment letters today in non-corporate. So such as the things has to be like there is an audit of terms and conditions of employment. We need to upgrade it. Yes, yes, Mr. Sorry for the interruption. That stuck to my mind. I thought of sharing.
No, I think this is awesome. I think this conversation, and I love the aspect that we are taking this conversation not only specific to the COVID-19, and there are a lot of things which are general, and we all as HR professionals and business leaders need to keep those factors in mind. Like the one, we ask people that we have a lot of huge HR policies and guidelines, and we sometimes forget to get acceptance from our people that they have gone through it. So which is not a good practice. Honestly, so I think these are really good conversations, and feel free to come up with your experience and the questions other people might have asked you and which you think will be good for this audience here. So feel free to do that. Before I go to the next question, I would take a pause because there's so many questions coming, and I would like to spend some 5-10 minutes out there to answer some of the questions out there. So some of the questions which are there, which has already been answered already by you. So but I would still like to call upon this question. So that in case you want to reinforce something and reiterate in brief about the questions which has already been answered by you. And if it is a new question and we have not touched upon it, then I would like to have a detailed understanding from you on that. So first question I'm taking is from Radhika. She is right now on the Zoom call, and she's asking, is it possible to ask employees to leave if they are not performing during this COVID-19 phase? That's an interesting question. There could be non-performance issue. It is not that the employer wants to lay off, but it could be a non-performance issue. What will be your suggestion in that case, sir?
Yes, Mr. Bhavin, that is a good question. The thing is that normally the IT industries where the employee is underperforming or not performing to the expected level is put under basically PIP, Performance Improvement Plan. First, basically, you put under the Performance Improvement Plan. And even during the Performance Improvement Plan, if the employee doesn't, during that period of PIP, if it doesn't improve performance, then you would be terminated. But the thing is that if the employee is under probation during the probationary period, and if the performance is found not satisfactory, he can be terminated, and it can be a termination simple titter, invoking the clause under the appointment letter that his performance is not good. Once if the employee had been confirmed and subsequently he was doing well, owing to various reasons in between his employment and he might not be performing well, he might be kept under wing. And mostly the thing is that one-to-one personal counseling is done, nothing is minuted, nothing is recorded, no acknowledgement is taken. And under such circumstances, suppose if such employee we had been put under the PIP, in short, if we can say that performance improvement plan, PIP doesn't improve his performance if he falls under the employee and workman definition, not under the managerial category. You have to follow the procedure of issuing a charge sheet, calling for an explanation, conducting an inquiry, calling objections over the findings of the inquiry, and giving a final show cause notice, and then dispute the disciplinary procedure to be followed. In certain of the states, the standing orders do apply to the industrial this ITITES. For example, the Karnataka, they said that the standing orders do apply to the ITITES industry. So even under the Shops Act, there is a procedure laid down. ID Act, there is a procedure laid down. So that has to be followed when who comes under the definition of workman and employee. Who comes under the definition of who are excluded from these definitions, contractual obligation, that they can be in the event if it they can put that in the event of anything that they are not meeting the targets or coming to the expectations and other things, the employer can terminate by giving 1 month notice or paying leave of notice. But similar clause for the workman category or the employee category doesn't work. And also Supreme Court said that in most of the cases they do say that I have given, he has accepted, I will give. Basically, the Supreme Court in one of the cases said the contract between employer and employee is a contract between lion and lamb. The contract among unequal parties is not a contract among the equal parties, and the employee doesn't give free consent, which is essential ingredient or essential condition of a valid contract. So we have to be careful when it comes to the situation like this. So when we come to the PIP plan for the employees who come under the workman definition or the employee definition, everything to be recorded, everything to be, because the courts, when it is challenged before the court of law, tons of oral evidence is equivalent to ounce of documentary evidence. Perfect documentation to be maintained.
Awesome. Great. All right. So I'll move on to another one. The question from Yogi, and I think we answered it. It basically says that lots of firms are also doing furlough. But as you said, this is not legally allowed, but it can be done if there is a mutual consent. Then there is another question from Karthik Pal. Our company is asking to give leave without pay for 2 months. I'm working at college, non-teaching staff. What to do? So this is basically not asking whether it's correct or not. It's basically from an employee perspective, seeking advice what to do here. So do you have any advice for employee where the employer is asking for 2 months leave without pay?
So employee has to give the consent. You cannot just say they are forced to apply leave where it doesn't require leave. Employee has to give. Suppose in the event a one-to-one discussion they can have it, and if the employee is willing to, let him make an application that he wants a leave for a couple of months, let there be a sanction and the procedure to be followed, then it is okay. It is not that employee without making any application for leave, employee just making a debit to the leave account of the employer, leave account of the employee. We cannot just deduct the leaves that are standing to the face of the account of the leave account of the employee unilaterally, until unless the employee voluntarily gives an application of leave, seeking leave. Application of leave and seeking leave, that has to be done. It cannot be. Another question, Mr. Govind, that the reduction of fee, reduction of payment, and deduction of payment is one aspect. The other aspect is there are appraisals and increments to be released. And the question that comes is whether the increments to be released has to be deferred, can be deferred or not, or appraisals can be postponed. This awarding and rewarding can be postponed or not is another question normally that comes. So the increment is a reward for performance. It cannot be demanded as a matter of right. But as per the law, minimum wage is the wage which is guaranteed under the statute. Over and above minimum wage is subject to performance of the employee, paying capacity of the employer. It is not mere performance. Paying capacity also counts. That is what called as a fair and living wage. So you can defer the increment because it is not a right. Even in the appointment letter, nowhere an employer commits that every year you will be given increment.
Yeah.
That is not. The appraisals can be different. Yes.
Yeah, I think that's important because there are questions that was in our list as well. So thank you very much for answering this, because the yearly appraisals are coming, and there are many organizations which believe they are not in situation. So thank you for answering that question as well. I see the question, are there on this? So maybe we might skip when we reach there on increments and promotions. So another question, sir, is for you from Ashima, and she's asking, is it legal to furlough an employee without giving notice as well as salary for the previous month? I think the answer is it is not legal. So I'll go ahead with this. Nishant has a question on EPFO. Let me know if that's one you would like to answer. The question is, what, in your opinion, could be possible positive aspects of government's EPFO reform in current scenario? That's an interesting one.
This is only for 3 months. They said that I think 12% is 10% can be paid. and it would be hardly of any relief according to me. And only the question that comes from out of this is it mandatory that we must do the 10%? Whether some wants to continue instead of availing this temporary 3 months period, we would like to continue the same system. And if we are not, if we are continuing the same system, are they violating it? Always every law says any scheme or any payment being offered by the employer is far more beneficial than than it is envisaged under the Act. Employer is at liberty to do. No one can prevent. It should not be less than that. More is always acceptable, and it's only for 3 months.
Yeah, and I think you're right. There are companies having this confusion, and I know that there was a clarification given that if an employer wants to continue with 12%, they can. So thanks for answering that too. Wow, that's interesting. Himani Sharma asking, is there any specific format or proper law for layoff an employee in pandemic? I think you explained that. Would you like to give a brief of that again?
Yeah, this layoff means, as I said, that whether it's a permanent laying off or whether it's a temporary layoff, if it's a temporary layoff, how many days it is, and idea permits at a time 45 days, and the number of employees, and if it's a permanent layoff, it is a retrenchment, you have to follow the procedure envisaged under the Act, what it said, that has to be followed.
Got it. I'm skipping some of the questions which I've already answered. I see an interesting question from Kunal, and this is on the third-party worker. And I think we didn't cover that piece. He says, what if the third-party workers are not coming on work due to this lockdown? Does companies still need to pay? And I think he meant the principal employer still need to pay the vendor and vendor to the other.
Yeah. Basically, the thing is the third party worker is nothing but a contract labor in simple legal language if we want to use it. This contract labor can be any person who is not directly employed by the employer, employed through an agent or employed through a contractor is a third party employee. And in the IT/ITES, normally in the manufacturing sector, they would be engaging such third party employees only for the workman category. When it comes to the IT/ITES, they engage the engineers, senior engineers, because there will be staffing companies who would be recruiting and supplying those employees, and there will be clients and your employees going and working at the client's place, and the client employee coming and working at your place, and all will be there. And there is two sorts of contract. One is the contract between principal to principal. Principal to principal, and such person working with you, you have no liability. The other one is a contract between the principal to the agent, where you give it only for supply of manpower. That is like a staffing company, where the employees, they continue to be on their roles, they come and work. Either they may work at their office or they may come to your office and work. But ultimately, except your work, they don't do any other work. Whether it's directly employed by you or not. There are basically two sorts of contracts if we have to academically in detail discuss about it. One is a contract for service. The other one is a contract of service. The contract for service is a business contract. The contract of service is an employment contract. The contract for service, for example, is the contract between the employer, principal employer, and the labor contracting firm or a staffing company is a contract for service. That is a business contract. The contract between the employee and the staffing company is a contract of service. So now the question that comes to is that the third party employee who is nothing but a contract employee, if he is not working, do you have to pay the wages or not? Earlier, prior to 1905, before this MHA order came and the other local governments have given certain orders, you'll have to pay to all the employees, whether employed directly by you or through a third party or through a contract labor, full payment has to be done. That is what. From 1905, there is no such things. And another thing is that even otherwise in general law, as per the Contract Labor Regulation and Abolition Act, which is the Central Act, the principal employer is jointly and severally liable for payment of wages. Whereas not liable for retrenchment, recruitment, appointment of a contract worker by the contractor. But when it comes to the wages, when such worker exclusively does your work supplied by a third party, principal employer is liable for the wages. And the law says when it comes to the PF, PSI and the wages, it is the primary responsibilities of the principal employer. If first should pay, then he can recover it from the contract.
Well said. Thank you very much. There is a question that's also interesting. He said, where can a manager level person approach if he or she is not getting salary paid from last 5 months? So you have any advice there?
Yeah. The manager level person who doesn't come under the definition of workman under the Payment of Wages Act, the thing is that he only has to file a civil suit as per the law that is today. Under the new wage code is covered, and that is yet to be notified. The date of implementation to be notified. As of today, the law that stands, he has to approach the civil court by filing a suit.
Got it. There is another one interesting situation. Somebody from Zoom, Nirpesh, is asking, so his question is basically that the salary is being cut by 25%, where the working days are increased by 5 to 6 days. How to resolve this situation? That's a different situation.
Yeah. Anything is salary cannot be just like that deducted or cut without the consent of the employee. As per as the working hours are concerned, it is common in the entire India that an employee who works for more than 9 hours a day and 48 hours in a week is entitled for the overtime at the rate of double the ordinary wages. If it is increased more than 9 hours a day, that is why, because in the IT sector they work for 5 days. 9 into the 5 is 45 hours. Still they will be falling below 48. And suppose in the event, because the per day they can't cross, even if you are asking, but it should be below 48. And some people say that they will be working for 12 hours a day for 4 days, then it becomes 48. No, it's not the week. Even a day also to be counted more than 9 hours a day. That is why he has said he is entitled for the overtime. Another thing is that deduction cannot be done unilaterally unless the employee agrees it. If there is a deduction or a delay in payment, there is a relief available under the Payment of Wages Act. And the Payment of Wages Act also prescribes 10 times penalty on the delayed and deducted payment.
Yeah. Awesome.
As
There's
of
one
today,
more.
as per the Payment of Wages Act, the employees who are drawing up to 24% only are covered under the Payment of Wages Act, but most of the cases they might be drawing more. Right.
Yeah, thank you very much for answering this. There's one interesting question from Radhika, that can notice period be 0 to 15 days during provision period? This is nothing to do with COVID, but a general question, can notice period be 0 to 15 days during provision period?
Doesn't say when it comes to the notice period, only when it comes to the retrenchment, they say that 1 month notice or pay in lieu of notice. That is what Section 25F says, or Section of the Shops and Commercial Establishment Act says. Or in the event where it comes to under Chapter 5E of the Industrial Dispute Act, that Section 25N says 3 month notice. But in respect to the general category, the notice period, how much it should be is not mentioned. It is all mutual and reciprocal. If the employer wants to terminate with showing a valid reason, it can be even without any notice also can be done. That, but it is naturally as per the, I always say that it is better to, it is not advisable for any employee to compel him to work during the notice period, to serve the notice period, because he will be having an attachment after detachment. It is not a complete attachment.
Yeah.
And he would be physically present and mentally absent. And another thing is his continuation would be prejudicial to the organization. That to be the, until unless the employee is so committed, we can't say all are bad, all are good. He is good and bad is everywhere. Depending on that, that is why I always say that in the employment letter, by giving 1 month notice or paying leave of notice, the services can be terminated. However, if the employer wants, he can purchase the notice period, make the payment of the notice, and relieve the employee even before completion of the notice period. That also, if we could put a clause, as and when the employer finds that his continuation is causing prejudice to the organization, like poaching the employees, soliciting the fellow employees, or whatever it is, avoid it. Or simultaneously working with 4 to 6, I will work with the new employer because he needs this person to be on board immediately. So, so all these things to avoid, always better to purchase. Similarly, the employee also should be given. Anything should be mutual, reciprocally, should not be one side. Employee also, if at all he wants, he can forego the pay and relieve, get himself relieved.
Awesome. And I think I know those conversations where HR and the manager is having conversations with employee who is not behaving to the best during notice period. And there are so many cases. So I know all of us can relate with that. There are two questions from R.K. Riza, and I'll take them one by one. And I need your quick opinion on that. One is that during this period, if employer refused to pay gratuity, what should employee do? That's one question. Maybe you answer that and I'll go to the next one.
Yeah. The gratuity is payable only on severance of employment, not while continuation in employment. And during the severance of employment. Suppose in the event, even during this period, if there is a severance of employment, gratuity must be paid, it cannot be withheld. And another thing, latest judgment of the Supreme Court, very recently, last week, that has come. What it says is that where the employer pays a post-retirement of the employee, post-severance, if there is anything is found irregularity on the part of the employer is at liberty to initiate disciplinary action even after retirement, even after severance of employment for any reason whatsoever. And then in that event, the gratuity can be withheld. And suppose if he comes out clean, it is okay. If it doesn't, it can be forfeited as per the procedure laid down under the provisions of the Gratuity Act. Earlier, in the same case, the High Court held that the gratuity cannot be touched and it cannot be withheld. That is the latest judgment.
That's interesting. That's interesting. Thank you for letting us know.
This is what the last week only this judgment just.
Yeah. Thank you very much. The second question he has is, and that's an interesting one. He said, what if that, I think you mentioned about some term which should be mentioned, the appointment before somebody reduce the salary of an employee. And he's saying, what if this term is not mentioned in the appointment letter, but now employer wants to amend the appointment letter at this point of time? What is your opinion on that? Is it possible? Not possible?
It should be bilateral, but not be unilateral.
Yeah.
If it is unilateral, it leads to the litigation.
Yeah. There is another one very interesting, and we didn't touch upon that. It says, what if an employee get affected by COVID-19 while on duty? Is there any compensation policy regarding this? And this is the question from Deepak W from our Facebook Live.
Okay, it's a good question, and that is why you always have to ensure that the employee reporting, looking into the temperature and other things, getting the tests done and other things, you don't know whether employee had already that COVID symptoms even before reporting duty or not. When it comes to the compensation, what it is said is that suppose in the event if he gets COVID somewhere and if he gets affected with the COVID somewhere, you are not liable. But there is a possibility while working in the organization, he says that a certain of the SOP in respect of carrying operations during the COVID period are not complied with the employer on account of non-compliance of this SOP, that he got contacted with the COVID and it happened in the course of employment, then he can attribute that to the employer and claim compensation. Negligence on the part of the employer in taking precautions not to spread the COVID while in employment. Otherwise, if he gets contacted somewhere else, it is happening in most of the companies now. Suddenly they are found and they are sent out, and again sanitation is taking place, entire office, but still that is not. Yes.
Thank you. There's a question from Samrat. I think we already answered it. It's because it's basically about reduction in salary. There is another interesting question from Gridhar, and I think what is basically asking is that is it possible for the employer to say that the employee will give 3 months notice, wherein the employee is supposed to give more, like, or less, like meaning there is a difference in the notice period from both the sides.
I got your point, Mr. Kohli. The thing is that when when he wants to leave, he has to give 3 months. When we want to leave him, even by 1 month, whether it would do or not. Okay. There is a saying in Telugu The thing is that when you come to my house, what is that you are going to give me? When I come to your house, what is that you are going to give me? Either way, it should not be. It should be mutual and reciprocal. It should be equal. Justice not only be done, it should seem to have been done. It is a equity. It is not permissible.
Yeah.
It should be equal.
So that means it is not right from the law perspective. Okay. I'll take another one. I'm skipping some questions in between because I think you already answered them, but that's interesting one about retention bonus. Priyanki is asking that his brother joined a company with a promise of a retention bonus, but now they are not giving a retention bonus. What to do?
Thing is that, that is retention bonus. Where it is under the as part of the contract, if it is not complied with, it is a contractual obligation, he is entitled for it. But I cannot give a constructive opinion until unless I read the clause, because while reading and interpretation, because any provision of law is the same for the petitioner counsel and the employer's counsel, employee counsel, it all depends how they interpret it. And very thin line interpretation will be there. It cannot just be said until unless we peruse the document, sentence, everything. There are certain things what they say is that the performance bonus. For example, I give you, because I exclusively appear for the employer and I don't take up the cases of any employee. And performance bonus normally is being cut. And most of the employers do put a query to him. No doubt I agreed under the contract the payment of performance bonus. Now he is not there when the appraisals is taking place. So whether I have to pay it or not. But during the performance period, the employee was there and he did give the performance. Is otherwise entitled for the performance bonus, and had he continued, had he not continued, also he would have entered. Because for that period of performance you are paying, not for the subsequent year. So he is entitled. But for again, in the event if there is any specific clause in the appointment letter, the performance bonus is an incentive being paid not only for the performance that has put in the year for which it is due, and also with a hope that the same performance continue to be performed in the continuing years, and he has to be on the rolls of the company as on the date of payment. So the objective of performance has to be clearly defined, not only for the performance what is achieved, and also with an expectation they continue to achieve in future. So such clauses has to be carefully drafted.
Yeah, and I think it again go back to the same thing that you, from your organization perspective, you have to make sure that whenever you are going with any kind of agreement with your employee, and you should be very careful in making sure it is win-win for both, and all the terms and conditions are clearly noted down and not to be left for ambiguity.
It has to be practical. It has to be. It should not be based on the assumptions, presumptions, surmises, and conjectures.
Yeah, and should not be unfair. Like, when I'll terminate you, I'll give you 1 month notice, but you have to give 3 months notice. All right.
Lies, but no, I tell always lies, nothing but a logic. Management is nothing but a common sense. Common sense is most uncommon.
You are very well said. We have a question from Avi Biswas, which is very interesting. He said that when organizations are hiring people, they want them to join early, but when their people are leaving, they put the notice period clause like 1 month, 2 months, 3 months. But his question is not whether it's fair or unfair. It's a practice. His question is that should we put notice period clause under Shop Establishment or Industrial Dispute Act? So that's an interesting question. Should we put it in Shop Establishment?
It can't be commonly put. There are employees who is not covered under the ID Act. There are employees who does not fall under the Shop Establishment Act. Why do you bring under them also under the purview of this act by putting the class? Tomorrow you can't have the difference that they are applied under the supervisory and managerial category, and the law is not applicable to them. So it has to be on case-to-case basis. We should not undertake it. Always better put the equal period. Not better, it is mandatory. You have to put the equal period. Whether it is from him or from us.
Perfect. All right. There is a. Go ahead. Go ahead, please.
Pardon? Yeah. No, that is, suppose in the event under the Industrial Dispute Act is 1 month notice or paying leave of notice, it is not simply paying. And they also said that without any valid reason. the payment of retrenchment compensation. When you specifically put it in most of the companies, what I found is that they simply give notice. They don't give any retrenchment compensation. Retrenchment compensation should be 15 days wages for every complete year of service. They will only say in the bargaining process, I will give you 1 month notice, 2 months notice, something like that. And when you put and quote the provision of the law, not only has to comply in respect of the notice, in respect of the other procedure that is prescribed and envisaged under the Act, and other benefits envisaged under the Act has to be complied. Whether it is mentioned or not, it has to be mandatorily complied. Doubt about it. As long as normally the question that do come is that why are you saying so? In the past we did several cases, nobody complained, and my neighboring company did so, nobody complained. What they follow is not the law. What is there in the law is law, and nobody questions me that we have to take it as we are lucky. Doesn't mean that the law is changed.
Makes sense. Thank you very much. There is a question from Jyoti Thodkar, but that's more related with guidelines to come back office. But I'll just ask that. Let me know if you want to answer that. She's saying that can offices be reopened with 100% capacity? I don't think that's possible because the lockdown is still going on.
5.0 has to come now. 5.0
But let's,
like the 4.0 this thing is that 5.0 we have to see. Today we may come to know Mann Ki Baat.
Yes. And I think, yeah, of course, it's not possible 100%. But would you like? I think the simple answer is that there are state-ruled advisory being published by all states, and there has to be followed. So, Jyoti, whichever state you are in, I would request that you go with the state, based guidelines out there. There's a question from Divya, and she said that if employees can be terminated, then what are the steps to be safeguarded? Okay, so I think your answer was that it cannot be, number one, and if you want to do it, it has to. I think you used the word winning over the employee. That you should win over the employee, have a conversation, make them understand your situation, and do it mutually. That will be a better solution than doing it forcefully. Is that correct assumption, sir?
Yes. And otherwise, if you want to do it unilaterally, you have to follow the procedure of the ID Act or the Shop Act, and you got to follow the law of the land in nutshell.
Awesome. There's a question from Gopal. He's saying, is it mandatory to constitute workmen committee under IT Act without any order from government?
No order is required. It is there under the Act, and works committee and workmen committee can be formed. That is, I think, Section 3 of the ID Act.
Okay, and there's a question. Sorry, there's a question specifically on, I think, APMPS. It says, what is the meaning of maximum number of employees employed in any given day as per the integrated return of labor law of Andhra Pradesh and Telangana, I believe? It's very specific. Do you want to address that?
I got the point. What it means that employee means when it comes to the factories department, that is a different thing. And when it comes to the ID Act, the person who comes into the definition of workman. And the other thing is that in the preceding 12 months, you have to take the average number, and that has to be mentioned, whether it is 100 or 200. It is not that yesterday's number or tomorrow's number or day before yesterday's number. It is preceding 12 months from that day. One has to arrive at average figure.
Awesome. So I think we have almost answered every question, but let me take a last one, which is a little different than others. It is from Ravi Krishna, and he's saying, what are the penal possibilities with respect to dual employment?
Until unless there is no law for prosecution of an employee for the dual employment. And in the event, if you mention in the appointment letter that during the course of his employment or the tenure of his employment, he should not be gainfully employed or in any other position here, it amounts to breach of contract, and he is liable for disciplinary action and the management. And there is no criminal prosecution as such for that.
Perfect.
And in the event, if he discloses any secrets of the company, business secrets of the company, that amounts to criminal breach of trust and it cannot be generally be answered. It all depends on the case to case, depending on the facts of each case.
Awesome. I'm tempted to take one more. So
Yes.
I will take it quickly. It says, can employer ask employee to report to their work location or you will be marked absent if employee has gone to his and her hometown during lockdown? That's interesting.
Yeah, this is the situation where it came, and soon after lifting of the lockdown, there are certain, even during the lockdown period, there are certain industries which are exempted. For example, in Hyderabad, the IT industry is exempted from the lockdown. They were permitted to carry their operations, and work from home also was there. And in mostly the IT industries, what is happening is that one is that they left to their native place and they can't come back and work physically. Second thing is that the internet connection at their native place is not proper. They are not able to log in, and these are the scenarios. So where they were asked to come and did not report duty, it is to be treated as an absent. Where such industry is permitted to carry its operations during the lockdown period.
Awesome.
If they are asked, if the employee as per law is bound to come and work, if he doesn't come, he is be treated as an absent. When he is absent, he is not entitled for the wages. Let us not think the reason whether he got and held up at native place or somewhere, we are not concerned. As per law, I got a right. I am permitted to carry my operations. I asked him to come, he did not turn up, and treating as an absent and not
Awesome. Thank you very much for answering all those questions. I see some of the questions where like people have asked to repeat certain things or they're asking the same questions. What I would suggest is that we will be publishing this webinar and interview with Mr. Murthy and put it on our YouTube, and we'll share the link with you guys if you want to go through the whole webinar one more time. Want to listen every question he has answered. I think that would be important for many of you. So we will be sharing the link on YouTube and you can find it from there.